G'day, I'm Stephen Page from Page Provan Family and Fertility Lawyers, and you're watching and listening to the Australian Family and Fertility Law podcast. Thank you for joining me. Today I'm talking about posthumous retrieval, storage and use of eggs, sperm and embryos in New South Wales. Well, the starting point is if we've got eggs, sperm or embryos, they are either in storage if we say that you're the widow, your husband has died, or we don't, and you're looking at a retrieval of his sperm from his body. So if you have these items in storage, then you cannot use them on the face of it unless there has been consent in writing to the use. And that's because of provisions of the Assisted Reproductive Technology Act of New South Wales. However, it's also clear from case law concerning storage of sperm in these circumstances, and some case law from the family court about who owns embryos, that you as the owner may be able to use or at least export them to somewhere else. And that may be to the ACT, it may be to another Australian state, or it may be overseas. It's really quite complicated. In some circumstances, you may be able to export to Queensland. On the other hand, if you have engaged in a retrieval, then you should be able to export to Queensland. Exporting to the ACT is more complicated because you will need an order for storage and use from the ACT Supreme Court. If you engage in retrieval in New South Wales, the thinking is, well, what I've got to do is I've got to go and get an order from the Supreme Court. No. The Supreme Court has said on a couple of occasions now that it does not, or it's doubtful whether it has jurisdiction to make such an order. The better approach, in my view, is to rely on the provisions of the Human Tissue Act, which means that you have to rely on a designated officer from a hospital, if the body is in a hospital, to order the retrieval. And they'll do that if the senior next available next of kin approves, namely if you're the widow, and there was no objection by the deceased to the use. However, there has been a policy document issued by the Chief Health Officer of New South Wales saying don't do that, because in what widows should be doing is going to the Supreme Court. What that's meant in practice has been designated officer, at least on one occasion, has declined to authorise, and what my client had to do on my advice was to move her late husband's body with the help of very professional, quick funeral directors to the Lidcombe morgue, and then she authorised there, because if the body is not in a hospital, then the designated officer is not the one to approve the retrieval. If the body's in the morgue, then there's always got to be a checking in with the coroner. If the coroner's jurisdiction applies, then the coroner also has to approve. If it's not within the coroner's jurisdiction, the coroner does not have to approve. Coronial approval happens quickly, so it's not something I worry about. But who do you get to do this work? Well, at the moment, unless you are lucky, and I've seen this happen in one hospital where a urologist did it, typically there is only one doctor and one clinic who do this work. And that one doctor is Dr. Derek Locke, L-O-K, with Genea, and the clinic who do the retrieval and storage is Connect IVF, which is based in Sydney. They're the only ones. None of the big IVF clinics do this work. And so if you think IVF Australia, Genea, Monash City, for example, none of them do this work. The only doctor who does this work regularly is Dr. Locke, and we work closely with him and with Connect IVF to make sure all the paperwork is done quickly and efficiently. Once the sperm is stored, then you can't use it in New South Wales because of the requirements of the Assisted Reproductive Technology Act. Almost certainly I'll be saying to export it likely to Queensland, and if you're exporting it to Queensland because it's the easiest way of being able to access the sperm, then the clinic in Queensland will need to be satisfied that the retrieval was lawful, that your possession is lawful, and ultimately that they can that you can be able to use it under Queensland law. So hence a long letter by me to the clinic saying this is what can happen. So I'm not worried about any of that. It can all happen, but the important thing is to act quickly because the time frame for retrieval is very, very short. Certainly contact me through my website or through Connect IVF or Dr. Locke. Any of us will get onto it very, very quickly as we have done before. Thank you for watching and listening. I'm Stephen Page from Page Provan Family and Fertility Lawyers, and this is the Australian Family and Fertility Law Podcast.